Well, the government wants to change the law and they're asking for your help. So what am I talking about? I've spoken in the past about the rather convoluted and complicated world of contempt of court and how a lot of it is very anti-intuitive because of just how it's evolved over the millennia and the centuries. And the general consensus is it's a bit of a mess. So they want to radically simplify things. But they're asking for people's assistance. They've put out a consultation document and I'll link to it in the description, because I think some of you will actually have some useful insights, because one of the things we need to look at is now in this world of social media and online commentary and people wanting to talk about court cases, obviously, that can amount to contempt of court, and we get into all this thing as to, what's active proceedings and that sort of thing, and how far should you be able to go, and does it matter if the jury see it? So this is going to be very helpful if you can chip in. But what we're looking at, what are the general proposals? Because the Law Commission have been tasked with this. They were instructed on the 9th of July, when apparently something happened that changed the government. And they've really hit the ground running. I mean, this has all been in the background anyway, waiting for the election. So what they're looking at, well, one thing they want to do is get rid of the distinction between criminal contempt and civil contempt, because those phrases are quite confusing. You can commit civil contempt in a criminal trial and you can commit criminal contempt in a civil trial, because it's not the nature of the proceedings that's relevant. It's actually, did I actually press record? Yes, I did. It's just before I talked to me there. It's the nature of the contempt. Generally speaking, criminal contempt is something that interferes with the course of justice generally, either a specific trial or just generally, like the sort of tipping off juries thing about their right to acquit, or is it a right, or is it a power? That's another thing that we can talk about at some stage. Whereas civil contempt is things like disobeying a court order, not filing something on side, not paying a costs order, that sort of thing. So they want to get rid of that distinction, and they're looking at having 3 broad categories. Although already I see a problem, because one of the categories has 2 bits in it which actually overlap with some other bits. But I'll read what they are, because I've actually made some notes. Well, I say made some notes, I'm just ripping off Joshua Rosenberg. There's a thing called general contempt, and that would include any conduct that interfered with the administration of justice to a non-trivial degree or created a substantial risk of that. The conduct could be in the face of the court, such as threatening a lawyer or a judge during legal proceedings, or it could be remote from the courtroom. So, for instance, all this, publishing confidential information online or inadmissible material. But they also want something called general contempt by publication, and that would be treated differently. And that would be you publishing something, but it has to be with the intent to disrupt proceedings or to cause trouble or to interfere with justice. So, there'd be a mens rea element, as we say. So, you couldn't commit that recklessly, although we will come on to that shortly. So, that's, that's the main category. Then there'd be contempt by breach of order, or indeed undertakings, because sometimes if a court's going to order you to do something, like grant an injunction, you can head that off and say, okay, we'll just agree to it anyway. We'll give undertakings, and you can do it without any admission of liability, that's one of the advantages, and say, okay, we will agree not to publish this, or we will agree to do something. But if you were to breach that order, or to fail to do that, that would be a form of contempt. But then there's also contempt by publication when proceedings are active. And that very much mirrors the old common law position, in that could be committed recklessly. So it doesn't matter that you didn't intend to disrupt the proceedings, but if your publication has that effect and you were just careless and didn't consider, then that would amount to that. But you see there's a bit of an overlap. I mean, already I'm thinking this should be 4 separate categories, and maybe the contempt by publication should be its own category and just have a intentional or reckless contempt. In terms of penalties, they're saying that it should remain as it is, so up to 2 years in prison or unlimited fines. But they're also saying there should be other options, like community service, things like that. So it's not just all or nothing. They're still recommending that contempt, whether criminal or civil, I mean that distinction would be abolished, it shouldn't be regarded as a criminal conviction. Because that's the case now, even if you're convicted of criminal contempt, and indeed you are committed to prison, which is distinct from a sentence of imprisonment, even though the terminology is the same. So in the old days we talked about prisons and jails. So really you were sent to jail rather than prison, because prison was for punishment and jail was just for locking people up for practical reasons, like putting them on remand or locking them up there until they purge their contempt, or to illustrate that the contempt, wasn't approved of. I mean, again, that's more of a subtle distinction, but it doesn't go on your criminal record, for instance. So even if you've been sent to prison for 2 years for contempt, you can still say I'm a person of good character and I don't have a criminal record. But then we get into this proceedings are active. And this is something that's a bit confusing, because it's obviously contempt. If a trial has started, then proceedings are clearly active. But what about if somebody's just been charged? Are proceedings active there? Well, the law tends to say yes, they are. But what if proceedings are merely contemplated? Well, again, that can actually amount to a contempt if you should have known that something is likely to lead to court proceedings. Then technically the proceedings can still be regarded as active. And this is like, when I'm sort of commenting on the post office inquiry and things like that, because, the authorities are very much sort of doing it, well, we'll just see what happens at the end before we do anything. But it seems to me obvious that some people will be proceeded against for criminal offences, or at least they should be at the end of this. So does that mean proceedings are active or contemplated? So if I was to say something, then in 5 years' time when there's a trial, that might prejudice a jury because I commented online about the behaviour of one of the lawyers or one of the witnesses. Would I be in contempt? So that's something they want to ask people about, is when do they think proceedings should start, should count? Can you comment up to the point somebody's arrested? Can you comment up to the point somebody is charged? Can you comment up to the point that the trial actually starts? And these are the sorts of, there's actually about 172 questions they're actually asking. And like I say, I'll link to the relevant consultation paper and you can see what you think. One thing though they are very keen on is, your Article 10 rights, because this government said they're definitely keeping the European Convention on Human Rights. So that means you have your Article 10 rights, your freedom of speech. And there does seem to be a bit more of a shift towards, actually, we should just let people comment. That's the recording? Yes, it is. We should just let people comment. Juries are considered to be quite robust. And, they always get, judges, if it's a judge-only trial, well, judges can do the mental gymnastics just to filter stuff out, so it shouldn't matter to them. But juries always get a direction, which is, look, try the case on the evidence in front of you, not what you've heard down the pub or what you've read on the internet, because there's no way of testing that. This comes back to this Letby thing with the New Yorker article. I know a lot of people are saying, well, I've read it and I find it quite convincing, but the fact is the defence chose not to pursue that case theory. So they obviously didn't think there was a lot in it, but if people are reading that, it's not tested, it's not challenged, nobody can cross-examine on it. So the idea is that would, present a sort of one-sided picture. So like I say, jurors are usually trusted to say, whatever you've read online, especially these days, they're told, don't go out and Google things, don't search for things, because that is also a form of contempt. But, they get this standard direction, and generally speaking, we do trust juries to do their job properly. The other thing that they're going to do is they're going to let lower tribunals, because at the moment only courts can do people for contempt, courts are proper courts. But what about tribunals, employment tribunals, even tax tribunals? We've got all these tribunals now. What they're saying there is they should actually have the power to initiate their own contempt proceedings, because now if somebody, say, kicks off in an employment tribunal, it has to be passed on to the court to deal with. But they're saying that tribunals should have their own powers to deal with their own contempt proceedings, although it would only be possibly up to 6 months. If they thought the contempt was so bad that it should attract a more severe penalty, then they would have to boot it upstairs. The other thing they're removing, or talking about removing, is courts can bring contempt proceedings of their own volition. But if you wanted to bring a prosecution for contempt, you would need the Attorney General's permission. It can only be brought with the consent of the Attorney General. But the argument is, the Attorney General is a government appointee. It's a government position, and they're appointed by whichever power is in party at the time. So what if the contempt is somebody where it's another politician or somebody involved in politics? Say for instance, somebody comments about something like a case that involves the government or a politician. Well, the argument there is there's at least the perception of bias in that it's a government appointee deciding whether a critic of the government should be prosecuted. So they're talking about removing the power from the Attorney General. I mean, but they're also very aware of, you get a lot of satellite litigation. You get this all the time in civil proceedings. The other side won't serve a document, or you think the other side have been dodgy, or you think their witness is lying. Well, they've got total immunity, generally speaking. You can't sue them, but then you can say, well, Judge, we want them done for contempt, so we're issuing an application for contempt. And they're very aware of this satellite litigation, and they want to avoid that. They don't want a free-for-all where everybody who just has a fallout with somebody suddenly brings a private prosecution for contempt. So again, how do they deal with that? Well, we don't know, but that's where you come in. The government would be interested in hearing your thoughts on all this, and I think we've got up until about November to get your comments in. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Like I say, I was actually reading some notes for once. Where am I today? I'm just at Malpass. I'm just opposite the Heron, because I came here. I mean, it's not particularly brilliantly framed shot or anything, but there's not a lot to look at because it's quite low water, so there's just lots of mud flats. And what is possibly a heron or an egret walking around. It does quite look like whatever's on the pub sign, so it could be a heron, but somebody better informed than me has said, no, it's probably just an egret. And I forgot, you've got to remind me of this, you've got to tell me to do this at the beginning. If you did find this useful, etc. or whatever, please consider liking, sharing or subscribing. Already got one subscriber from a lovely lass who's just sat in the car next to me I got chatting to.